Hey guys, this is Navdeep Singh Jitla. Thank you for clicking this thumbnail. Today we're going to talk about a temporary residence application. And this is an application for a visitor visa which was applied in 2018 recently. And the applicant name is Mannat Pal Kaur Anand. She applied for a TRV, a visitor visa, to visit their family members there in Canada, but it was refused. So let's see what happened. So the applicant was born in Iran on January 22nd in 1991, but is a citizen of India. The applicant is a lawyer practicing in Punjab and Haryana High Court in Chandigarh, India. The applicant's parents are Mr. Daman Pal Singh Anand, the applicant's father, and the Manpreet Kaur Anand, the applicant's mother. So the applicant has a number of Canadian relatives, including her maternal uncle, Pali Bedi, Manpreet's biological brother, Pali Bedi's wife, Navpreet Kaur Bedi, collectively referred to as a Bedi family, and her brother, Gavanpreet Singh Anand. Gavan was born in Canada when her mother visited Canada on a visitor visa in 1988. Her maternal aunt, Kanwalpreet Kaur Dutt, Manpreet's sister, her mother's sister. So the applicant earns a modest annual salary working as a lawyer since 1984. The applicant's parents have owned and operated a fashion boutique in India called Mannat Ladies Point. While the applicant's parents have titles to property and or relatively significant assets, the applicant herself has much more modest financial connections to India. The applicant as well as Daman and Manpreet applied for TRB in April 2018, ostensibly to travel to Calgary to visit their relatives. This initial application was rejected on May 11, 2018. The officer in the tick portion of the response indicated a number of reasons for refusing the initial decision, specifically travel history, purpose of visits, personal assets, and financial status. The applicant refiled a new visitor visa application on May 26th, 15 days later. The new visitor visa application included information indicating that the applicant was a lawyer. So in the second application, the applicant tried to justify whatever the questions raised in the refusal letter. The applicant responded with the arguments that okay, they are having the answers and this application should not be refused in first place. So the applicant refiled a new visitor visa application on May 26, 2018. The new visitor visa application included information indicating that the applicant was a lawyer who earned a modest annual income in the last year. So the applicant also filed additional information on travel history and the purpose of visit. Probably she was having some travel history. She might have traveled to some other countries, but it's not mentioned here anyway. So these are the questions which are raised in the judicial review. But before that, let's jump to the GCMs Notes so that we can get better clarity why visa officer refused this application. So these are the GCMs Notes, if you can see right here. I have reviewed all the documentation provided for this application. Summary of key finds below. Integrated search record on family members in Canada. Obviously she was having family members in Canada and she was trying to visit them. That's okay. Client declared previous PR, federal skilled worker applications which were refused or closed. So the applicant applied for permanent residency earlier in the past, but the application was closed, probably refused. It's not mentioned here anyway. But it shows that the applicant was having an intent to settle permanently in Canada. But let me just clear you guys. If you are also under the impression that if your permanent residence application is already in process and if you will apply for a visitor visa and it might get refused, so these are two different things. I understand if you are applying for a tourist visa, you must have an intent to come back, obviously, but as long as your intent of going there, your purpose of visit is valid enough and you have enough strong ties to come back to your home country, even if your permanent resident application is in place already or in the process, you will get the temporary resident visa. It must be that you must have pull factors to India so that you will definitely come back to India. You just have to convince the visa officer and also convince with the purpose of your visit. You will get the visa. The law will not restrict you or restrict the officers to issue the visa. Okay, let's move ahead. Principal applicant limited declared family in the home country. Strong pull factors to Canada. Okay, the officer noted that the applicant is having much more family members in Canada as compared to India, so it may be most likely that the applicant might not return back because they're having family established over there. Son is a Canadian citizen by birth and was born when mother visited Canada in 1988. Okay, this is the applicant's brother. Mother also has 2 siblings in Canada. Insufficient proof of financial status. See proof of funds on the file. Modest income shows on ITR. Modest income shown on ITR. Principal applicant family does not appear established in the home country. Probably based on the income of the applicant, I guess she only supplied documents for 1 year only, like the income documents. So we always encourage applicants to apply with at least of 3 years of ITR, because that is something which impressed the visa officer, that if someone is earning handsome amount of income yearly in India from last 2-3 years, so that is something which is very positive, and obviously it leaves a positive impact on the visa officer and further plays a very important role in the decision making. So she only supplied the 1 year of ITR as far as I believe, and principal applicant does not appear established in the home country. Given foregoing, principal applicant has not demonstrated sufficient establishment or sufficient ties to motivate to return. Probably she was single, she was not having any property on her name, she was working as a lawyer from quite a number of years, but still her income documents were only supplied for 1 year. From the visa officer standpoint, I also feel that she did not demonstrate enough strong ties or pull factors to come back to India. So we understand that her parents might have properties and everything is going well for them, but applicant is over 18. Obviously the applicant is an adult, so she's not having anything on her name, and also didn't supply the income documents for at least 3 years. If I was the visa officer, I would have refused this application based on the factors which visa officer mentioned. I'm not satisfied on balance that principal applicant is a bona fide visitor to Canada who will depart at the end of the authorized date. Now if you'll ask me whether the previous PR application played any role in this decision. Okay, if you ask me if the previous visa application played any role in this decision, I would say no, because even if the applicant applied for a permanent residency and she disclosed it already, but the point is, like, for this particular trip, she is not convincing me that she would come back. I'm not sure that she economically established. I know she's working as a lawyer, but I'm not sure about her income, and I'm not convinced that her income would motivate her to come back to India. So obviously the application is refused. So these are the questions and reasons further raised in this application. A lack of financial ties to India. I don't find the applicant's argument that office erred by not considering cost of living in India relative to her income. You can even check this particular case on the internet, it's publicly available. So dual intent, the officer in weighing the evidence considered all the factors, including that she came to Canada and she would not leave. This cannot be characterized as dual intent, and she was asking for a visitor visa. That should be the only intent. Yeah, I think it was the only intent, but anyway. So let's see the decision, like, for this judicial review, and you can even read this, the application was dismissed. So the visa officer noted the things correctly, and I think visa officer had taken the right decision. So there are 2 things to learn from this case. One is always supply at least for more than 1 year of income tax documents. Try to submit at least of 3 years of ITR, because that is something which impresses the visa officer the most. Secondly, if you're having relatives in Canada, you also need to get aware that might backfire, because that plays a negative role. Sometimes if you're not having stronger ties to India, your home country, so the relatives in Canada might play a negative role.